Hello and welcome to the Entrant. The topic for today's discussion is the Plea of Alibi. This is one of the most important topics of the Indian Evidence Act 1872. So, let's begin with the introduction. Alibi is a Latin word which means elsewhere. It is used when the accused takes the plea that when the occurrence took place, he was elsewhere. Where an alleged offence has been committed and the prosecution accuses person of having committed the same, it would be a complete answer to the accusation for that person to plead that he was at that time elsewhere. And if that person succeeds in establishing that plea, technically called the plea of alibi, he will be entitled to an acquittal. Moving to the Indian Evidence Act, which deals with the plea of alibi. Section 11 of the Act provides that when facts not otherwise relevant becomes relevant. Firstly, if they are inconsistent with any fact in issue or relevant fact. Secondly, if by themselves or in connection with other facts they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. If we go through the illustrations given under section 11, it says that where the question is whether A committed a crime at Calcutta on a certain day, the fact that on that day A was at Lahore is relevant. The fact that at the time when the crime was committed, A was distanced from the place where it was committed would render it highly improbable, though not impossible, that he committed it is relevant. Section 11 attempts to state in popular language the general theory of relevancy and may therefore be described as the residuary section dealing with relevancy of facts. The section includes two types of facts. The first clause lays down that the facts which are inconsistent with the fact in issue or relevant facts are relevant. The second clause provides that the facts which by themselves or in connection with other facts make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable are relevant. We shall take up two parts of the sections separately. Firstly, fact inconsistent with any fact in issue or relevant fact. One fact is said to be inconsistent with the other when it cannot coexist with the same. Let's take examples. When A is illiterate is a fact. Similarly, A wrote a defamatory article damaging the fame of B is another fact. Now, these two facts are inconsistent with each other. They cannot coexist because if A is illiterate, he cannot write an article. Vice versa, if he can write an article, he cannot be an illiterate. Therefore, if A charged with writing a defamatory article against B, the fact A is illiterate is relevant under section 11. There are generally 5 classes of cases that arise for consideration under this clause. First is plea of alibi. Second is non-access of husband to show illegitimacy of issue. Third one, survival of the alleged deceased. Fourth one, commission of a crime by third person. And last one is self-infliction of harm. Talking about the plea of alibi, the plea of absence of a person charged with an offence from the place of occurrence at the time of the commission of the offence is called the plea of alibi. If the plea of alibi is raised by the accused, the burden to prove it lies on him, which he could do by leading evidence in the trial. Now coming to the burden of proof, in case of alibi, we can refer a case in Binay Kumar and others versus State of Bihar. It was held by the Supreme Court that it is basic law in the criminal case in which the accused is alleged to have inflicted physical injury to another person, burden is on prosecution to prove that the accused was present at the scene and has participated in the crime. The plea of the accused in such cases needs to be considered only when the burden has been discharged by the prosecution satisfactorily. When the presence of the accused has been established satisfactorily by the prosecution through reliable evidence, normally the court will show to believe any counter evidence to the effect that he was elsewhere when the occurrence happened. While talking about plea of alibi in relation to co-accused, the plea of alibi cannot be accepted in favor of an accused merely on the ground that same was accepted in relation to the co-accused. To discuss the consequences of failure to establish alibi, we can take reference of the case of Sankarlal versus State of Maharashtra, whereby it has been held that failure on the part of accused to establish plea of alibi does not help the prosecution, and it cannot be held that the accused was present at the scene of occurrence. The prosecution must prove it by positive evidence. In another case, Disari Siva Prasad Reddy versus Public Prosecutor as well, the court held that the mere failure on the part of the accused to establish the plea of alibi shall not lead to an inference that the accused was present at the scene of occurrence. Now, coming to the clause 2 of section 11, it provides the facts making the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. The words highly probable point out the connection between the fact in issue and the collateral facts sought to be proved must be so immediate as to render the coexistence of the two highly probable. The section makes admissible only those facts which are of great weight in bringing the court to a conclusion one way or the other, as regards the existence or non-existence of the fact to be proved. In Brijlal Prasad Sinha versus State of Bihar, the police officers were tried for murder of some alleged culprits in encounter. It was alleged by the police officer that the occupants of vehicle used by deceased were also firing from their firearms, but ballistic reports showed that the pistol found near dead body from which the deceased were alleged to have fired were never used, and also that those arms were defective. Thus, ballistic report was admissible under this section since it made the existence of fact in issue, that is, whether the deceased fired or not, highly improbable. It was more so when it was found that glasses of vehicle in which victims were travelling were broken, and there were no marks of firing in which police officials were travelling. So, the accused were held liable to be convicted. Let's move on to another term used in clause 2 of section 11, that is highly probable. It must be borne in mind that in this clause only those facts are relevant which make the existence of the fact in issue or relevant fact highly probable or improbable. The words highly probable are of great importance. Whether a fact is to be admitted under the clause or not depends upon the weight to be given to such evidence. To be clear, this clause allows the admission of those facts only which after being admitted will be of great help in bringing the court to a conclusion as regards the existence or non-existence of the fact in issue. If the facts are of little importance, they cannot be admitted in evidence. The words highly probable mean more than normal standard of probability. Now coming to the next point, that is section 11 controlled by other sections. The terms of section 11 are no doubt wide, but they must be read with other sections of the Act, and therefore the fact relied on must be provided in accordance with the provision of the Act. Section 11 is subjected to control by Section 32. As a general rule, Section 11 is controlled by Section 32, where the evidence consists of the statement of persons who are dead or cannot be found, but this is subject to certain exceptions. The test whether the statement of that person who is dead or cannot be found is relevant under Section 11, though not admissible under Section 32, is that it is admissible under Section 11 when it is altogether immaterial whether what the dead man said was true or false, but highly material that he did say it. In case of Thakurji versus Parmeshwar Dayal, it was held that since there is difference between the existence of a fact and statement as to its existence, Section 11 makes admissible the existence of facts and not the statements as to such existence unless the facts of making that statement are in itself a matter in issue. So, to conclude, it can be said that merely because the plea of alibi has been taken by the accused, the same in no way reduces the possibility of the accused having committed the crime or dispenses with the burden of proof on the accused to prove his alibi. The accused must prove his plea of alibi beyond reasonable doubt and with strong evidence in support. Only then it will be accepted by the court in a criminal trial. Needless to say that the prosecution will have to independently prove that the accused has committed the offence because as per the law in India, an accused is generally presumed innocent until proved guilty. Thus, it is not necessary for the accused to raise the plea of alibi until and unless the prosecution has discharged his burden of proving the accused guilty. If the prosecution has failed to prove the guilt of the accused beyond reasonable doubt, then it will not be important for the accused to prove his defense of the plea of alibi. But if the prosecution has discharged his burden, then it is important for the accused to prove his plea of alibi for proving the fact that he wasn't present at the place where crime was committed. Ultimately, it will be on the court to measure who has more weightage, the prosecution side in proving the guilt or the defense side in proving the innocence of the accused. I hope this video was helpful for better understanding of one of the important topic of Evidence Act, that is plea of alibi. For any further queries, please drop your questions in the comment box below and don't forget to like, share and subscribe. Thank you.